Hello, welcome back to Starting Up and Right, Conversations with a Startup CFO. I am your co-host, Trey Nicholson. Joining me is our Startup CFO, Ryan Keating. Ryan, good to see you again.
Ray, nice to talk to you. Good to be back.
Good to be back. Yeah, this is going to be a good episode. Joining us today is Hogene Choi, a partner at Morrison Foerster in their patent strategy and prosecution group. For more than 20 years, she's been advising startups and tech companies on intellectual property. And today we get to have a conversation, enjoy a conversation between you and Hogene around IP and patents and how that can play a part in informing your startup, informing your pitch, and informing your approach to your technology and your IP. So Hogene, welcome to the show. Thanks for joining.
Thanks, guys. Thanks for inviting me to join you.
Yeah, thank you for coming. So, this is always an important topic for our early stage clients, especially when it comes to fundraising and protecting obviously what they think at least is their intellectual property. And there's always a lot of concern and secrecy around stealth mode and the very early stages. And so I'm really looking forward to this. I think people will find it very helpful to understand really how do patents play in, especially in an early stage. How do investors perceive them? How does the market look at them in terms of defensive or even license? And how does a founder even understand, what do I have that is something that I should think about patenting? And I think that's exactly, Hogene, where you and your firm and others come in. So would love to kind of get into some of the questions and get and share some of this information.
Yeah, well, let me throw out the dumb question, if that sounds good. Just back up to the very beginning. Assume I'm a startup founder and I know nothing. What is intellectual property and what is a patent?
Thanks, Trey. There are a number of different forms of intellectual property. Patents is one form. You've also probably heard of trademarks, copyrights, trade secrets. A lot of those different forms of intellectual property are well known, but patents are a little bit more mysterious to most folks. And it's important to define exactly what you get with a patent. It allows you to block your competitors from making your invention, selling your invention, or practicing your invention. That means that you can block out the marketplace. It does not actually permit you to create or make your invention. So that's a fine distinction there. You can block others from the marketplace. It's not about permission to create. So you can actually patent something that is not technically illegal, such as online gambling.
Well, Hogene, you mentioned the word protection. It's a little bit of the idea behind protection. I'm a startup founder. I've thought of something pretty neat, pretty unique that I think. How do I protect my inventions? What are some of the questions you'll start asking me to help me build a strategy around protection?
Sure. With a patent, it needs to be directed to an invention, and that means something that is new and non-obvious over what's already existing in the state of the art. Most entrepreneurs know what the current state of the market is for their business model, for their technical inventions, and they're trying to launch something that they think is new and different. So you want to take that knowledge and apply it to what you think your patentable inventions are. Your patentable inventions may include technology that is used internally. It could be technology that is external facing. For example, it could be an app that your customers use. It could be your internal process for manufacturing a product. It could be the interactions that occur between your servers and another company's servers and maybe your customer's app. There's a lot of different areas for potential patenting. It really depends on what your business offering is, what the service or product is.
So Hogene, just in a follow-up to that, how do you work with early stage companies, entrepreneurs, to even help them identify what things could be worth patenting? If they don't come to you with already these ideas, figured out, like these are the three things that are unique and patentable, how do you sit with them to help flesh that out?
Sure. That's one of the early and important conversations that I have with entrepreneurs. It requires some inventor education. So the entrepreneurs need to understand what is a patent, what does it get you, How do you identify patentable inventions within the entire space of products and or services that you're building? And how do you capture those inventions? Oftentimes that last aspect, how do you capture inventions, is one of the most important and difficult things. Having regular meetings with your engineers, with your inventors, really encouraging them to elicit ideas, to offer ideas about what they are working on, what could be new, what could be different, and to really think about that along the way. That all of that is really important. Oftentimes, for early stage startups, you have an idea at the very beginning about what is new and technologically different, what differentiates you from other competitors in the marketplace. So I try to have a conversation about that with the entrepreneurs, helping them to understand what is it about that particular aspect that is new and different. Now, this is where it's very important to distinguish between business innovation and technical innovation. Patents cover technical innovation. There are some aspects of business that you can try to file a patent application on, but that's usually directed more towards how the technology plays in to your business innovation. And are you innovating in a technical way that enables that business innovation?
Yeah, you mentioned that the distinction between the business uniqueness and the technical uniqueness, I guess. And software patents, I'm not an engineer, but I do dally in code a little bit. And there's a temptation as a software engineer to think everything was obvious about a software patent. How do you kind of approach the question of obvious? That's such a vague term. Is it getting, is the definition getting easier to define now, or is?
Sure, Trey. The definition of obviousness really comes down to whether or not someone who's familiar with that technology and the state of the art would have thought to combine two different sources, three different sources of information in order to come up with the solution that you're trying to patent. So that idea where it's obvious because perhaps one patent that's already out there on a technology informed you about a lot of the bulk of the invention. And then when you take a look at some other technical white paper, someone else's patent, something like that, it fills in the holes for you and really sort of teaches you how to combine those things and come up with what is the equivalent of your invention. So obviously in the software space in particular, there are a lot of people constantly developing all different kinds of software. You also have a fairly low threshold for innovation when it comes to starting companies. With a life sciences company, with a pharmaceutical company, the threshold for starting a company is quite a bit higher because you've got to invest a lot more into R&D upfront. You have the entire FDA regulatory process, and all of those various hurdles add time and requirements for additional investment. When it comes to software, it's a lot easier for two guys in a garage, just like the HP model, to just start writing software and creating something that is different and new. So in those cases, you really want to come back to two core questions. First of all, why did you even bother to start this company? Did you think that you had something that was really valuable, new, and different? We need to talk about that. The other question to ask is, was there some problem out there that had been out there and existing for a long time, and you're the one who came up with the great solution, or you're the one that came up with the better, faster, more powerful solution? That's another topic we should talk about.
And I think maybe related to obviousness, I think is this temptation for the entrepreneurs that we work with a lot to try to go out and search for what's out there. Basically, I think in patent language, it's called prior art. How do you advise, or how do you think about entrepreneurs, or talk to them about kind of how much they should they be looking for when it comes to this notion of prior art, and what is that actually? Yes, that's a good place to start.
Sure. Prior art covers all of the documented technology and disclosures that were out there before your it's really these days a patent application filing date. It's not even about the date when you invented your invention. The US is now on the same timeline as the rest of the world. So when you invented something doesn't matter. All that matters is the date when you file a patent application. Everything prior to that date is potential prior art. So prior art can include, and prior art is what can be cited by an examiner at the US Patent and Trademark Office to reject your patent application. These are the references that they'll point to and say, your invention is already effectively disclosed to the world, because when you look at this technical white paper, this other patent that is issued, this other patent application that was filed, and maybe even it didn't issue into a patent, but that's still prior art. You know, it could be a blog post, it could be a user manual. I've seen a lot of different forms of prior art cited against patent applications, but they're typically patents or patent applications that have been published.
And what kind of advice would you have for entrepreneurs, just to keep using kind of our client base, in like looking for prior art before they come to you? Or, you know, is it better for them to do research, or for them to maybe not go out searching for something that could invalidate their patent?
Right. So the problem with searching for prior art, with getting on Google Patents and looking for whatever might seem similar to your invention, is that you are now under a duty to disclose every single reference that you might have found that is deemed to be material to patentability, is the phrase that the Patent Office uses. So any reference that you might have found that the patent examiner might have found interesting when examining your patent application, you are now under a duty to disclose all of that. And so if you go off and do a Google patent search and you just put in a few keywords and you end up with, in the software space, it wouldn't be unusual to come up with maybe several thousand references. Now you need to go through all of those, figure out which ones are material to patentability, which ones you might be under an obligation to cite to the Patent Office. Now, simply taking that entire list and providing that to the patent examiner is going to be rejected. The patent examiner is going to say, no, you need to do the work to figure out which of those references are actually material to patentability. And they will basically keep at you until you come back with a much shorter list, maybe like at most 100 references or so.
Wow.
So now you are incurring the time and effort and potentially attorney's fees if you're asking your attorneys to review all of these documents, because they will probably understand best what is actually fitting into that legal standard of material to patentability. You're now racking up, I don't know how many hours, how many dollars trying to identify the references that actually meet that standard. Now, what happens if you don't do that? If you just say, okay, I'll just do a quick search, I'll just see if there's like a lot or a little bit, maybe I'll look through a few of them, but who's going to know that I searched Google, right? The problem is, if there's any record of that, if you talk to anybody about the fact that you did that search, if create any sort of written evidence, and if you just forget and mention it to someone later on, all of that is potential evidence that later on, if you actually file your patent application, you actually get a patent issued. Let's say later on you try to assert it, or someone else that you sold the patent to tries to assert that patent, and someone else during litigation, during discovery, where you're compelled to produce all of your documents, all of your files, all sorts of things you may have to testify, that information could be discovered that you did that kind of a search. At which point, the fact that you did not satisfy your duty to disclose any of those documents that were material to patentability, that now can invalidate your patent. And of course, once that patent is invalidated, that can have a number of downstream effects.
So the fact that I would have done that research is potential evidence that I didn't come up with my creation independently. Like I was using the patents to actually enable my own creation.
It's not about the fact that you didn't invent it independently. It's really about the fact that the patent office and most folks assume that you are the person, you as the inventor are the person who has the best knowledge about what else is out there that's reasonably similar to your invention. They assume that you are generally familiar with the technology in that space, the other products in that space, the services in that space, that because of your general familiarity, that is why you bothered to go pay all of the USPTO patent office fees, to pay an attorney to prepare a patent application, and you made that investment into filing a patent application. Mm-hmm. So because of that assumption that you know best about what is out there, and also it's not just a one-time at the time of filing duty of disclosure, it's a continuing duty. So throughout the time that it takes to actually get from filing to an issued patent, which may be several years, typically is several years, you have a continuing duty throughout that entire time to disclose to the patent office anything that you find that appears that it may be material to patentability. So this could include research on your competitor's website if you find some technical data sheet that appears to be important and that something that maybe the patent examiner would want to know about. It is your duty to disclose those documents. If you are handling prosecution on your own, or if your attorney is, that's the point where you would prepare what's called an information disclosure statement, citing those references. And if it's not a patent reference, you may have to provide a copy of the reference as well.
Do you have a preference? Like if a client walks in your door, do you have a preference? I always come back to the thought, is it better to ask forgiveness or permission? Is a client that walks in your door that paid no attention to patents that they may have been infringing upon, or they did no research, they show up green with something they've built and they just hand it off to you to say, what have I got? What do I need to do here to protect myself? Is that easier than somebody who walks in and they've done prior art research? What's your preference? How should I prepare myself as a startup founder for a visit with Hogene?
I think as long as you've really done the market research on your business model, you will have enough information. If once you've done whatever technical research you needed to do to feel comfortable, to feel like this product or service has potential, it can work, the business model has legs. If you're ready to come pitch to Ryan and tell him that you've got a viable business idea, then you are ready to talk to me as well. In either scenario, we may handle them slightly differently, but I want to also, getting back to your question, I want to make sure to differentiate whether or not someone is infringing someone else's patent from whether or not you should file patent applications on your own inventions. Those two are totally separate and different and don't have any relationship really to one another. It's entirely possible, and given the volume of patents out there, perhaps even probable that you may be infringing someone's patent, but that has nothing to do with whether or not your inventions are worth patenting. I will say this additional point on that. If it turns out that your competitor has a patent on something that is involved in your invention, if you get a patent on something that your competitor is also doing, or maybe just your competitor is doing, even if you're not doing it yourself, if you happen to later on get into competitor lawsuit, where you're each, they're now suing you for infringement of their patent. If you have a patent on their technology that you can then counterclaim with, you have some ammunition in that fight. Now, if you don't have any patents and they just have patents on your invention, it's a pretty one-sided fight.
And that's, we've seen that quite a bit with our clients. I have to say more so 10 years ago. I think there was a lot of software patents that were issued and maybe not a lot of real understanding of kind of the uniqueness of them. And I remember there was a period of time where we had several of our clients try to assert patents that ultimately would end up being like disqualified. I forget what the proper term is, right? Invalidated. Yeah. And so how do you think about that when you actually own a patent? And do you assert it, or do you save it for a defensive move, like we'll swap patent portfolios? Or has that trend kind of eased up because the patents that survive are solid ones now?
So I'll say this: if you got a patent related to software that issued before around 2014, mid 2014, that's when the Supreme Court came out with their decision in what's commonly known as the Alice case. So that decision really not only changed the entire landscape for software patents, it threw everything into a lot of indecision and upheaval for a while. And so the Patent Office examiners were having a lot of difficulty understanding how they should be examining software-directed patent applications. In addition, a lot of different people out there who are patent holders or defending themselves from patents also were facing a lot of uncertainty as to how to identify which software patents were problematic, which ones were fine. And so there was a period of a few years where a lot of that was shaking out. But if you have a software patent that issued from prior to mid 2014, and that is where I would really think about potentially putting your patent, your issued patent, and again, this applies to issued patents, not patent applications that may have been filed before that time and are still in prosecution or more recently issued. If your patent issued before mid 2014, I would really take a look at the cost of putting it through a reexamination process. Now, with the ex parte reexamination process, you can take your patent, throw it back into the prosecution process, have an examiner look at it again under the current standards for subject matter eligibility. And they'll be able to give you a much better idea of whether or not you need to amend the claims, or perhaps, hopefully not, but perhaps there isn't anything in that patent that is going to withstand that new standard for subject matter eligibility.
And I'm assuming a reexamination process could end up with them deciding that this patent shouldn't have been issued in the first place? Is there that risk, or is it?
There is that risk. However, you will have the opportunity to amend your claims. Okay. And so it's possible that you just need to tweak them a bit, and then you'll be able to have an issued patent again, albeit something that's probably a little bit more detailed and verbose. But the alternative is, it does cost money and time. So if you are in urgent need of running out and suing a competitor right now because of what they're doing, it's important to recognize that the reexamination process does take some time, and it's not going to be a free process. You do have to pay the usual attorney's fees and go through that entire process. So it's important to make a careful assessment of how business critical it is to have that patent, to maintain those claims, and whether or not it might even be possible to get something of value in the end. One additional aspect to mention, Ryan, in response to your question, is that you can also file what's called a reissue application. So a reissue application is where you think that there may be some defect in your claims, and you're able to clearly state what the defect is. This is another way of going through the process of having the Patent Office look at your patent application again, but it's from a slightly different perspective. So you would need to identify precisely, and it's often difficult with subject matter eligibility, because you want to say that you still think your software patent should be patentable. And so you can't make the statement that there is a defect in the claims. However, it's possible to make that statement with respect to the scope of the patent claim. So if there is something in the patent that you did not claim, that you should have been able to claim, you can file a reissue application. If you are within 2 years of the issue date of the patent, you can actually file what's called a broadening reissue application. And so you can attempt to broaden the scope of the claims. Again, that's only up until 2 years from that issue date. But that is another basis for filing a reissue application. And of course, during that process, the examiner would look at subject matter eligibility, especially for a software patent.
Hogene, help me think through the difference between trade secrets and patents. I always think of the secret formula for Coke or Google's PageRank. They didn't patent those; they guard those very zealously, right? What's your advice to me if I think, how do I weigh out? Should I keep a trade secret, or should I patent this?
Thanks for asking that question, Trey. One of the important things to ask yourself is, what is detectable about your invention? So with a product, if you take it apart and you're able to see after taking the product apart, or maybe even just from looking at the product, if you're able to see the invention, then your invention is detectable just from the product, looking at the product. If you're able to look at your app or the service that you're providing through a web browser and see the invention or figure out the invention just by interacting with it, then your invention is detectable purely by using the app or the software. There are other ways of finding an invention, especially with respect to software, that are much more onerous and more challenging, but still possible, such as if you can look at the software code for your product and figure out by looking at the code whether or not a particular invention is being used, then it's also detectable in that way. That can sometimes come up when companies provide libraries or interfaces to outside parties who may need to interface with their software. But that's the question you need to ask yourself is your invention detectable based on the products or services that you're putting out in the marketplace? And I'll give you an example of something that may not be detectable. So for example, if you have a very specific process for combining certain chemicals and processes inside of your factory, and you are heating them for some period of time and then cooling them and heating them again, and all of that is purely being done within your factory, the final product that goes out may have no ability whatsoever to actually detect what that process was, what chemicals you used, what were the various heating and cooling steps, and for how much time. That is something that may be best kept as a trade secret, that process. If that's your secret sauce that enables you to, for example, I have this protector on my cell phone screen that's supposed to be incredibly not possible to break, not possible to scratch, super clear all the time. Whatever technology went into that glass is something that was in the manufacturing process at the factory. So that sort of thing, it may be very, very difficult or impossible for anyone who just has that product in their hand to figure out what that patented invention was, if you patented it. In that case, it may be better to not patent it. The important thing to understand with a patent application is that because you are getting a 20-year monopoly enabling you to block other people from practicing your invention, the reason why the government is willing to grant you that benefit is because you're also providing the benefit to the public of educating them about your invention. You're disclosing, you have to disclose the full extent of your invention to the public. So it's that exchange, benefit for the public in exchange for a temporary monopoly on that invention. That's why the patent system exists. So you have to completely disclose your invention, and the protection only lasts you during that 20-year term. Now, the recipe for Coke, as I understand, has been a secret for a very, very, very long time, much longer than 20
How do they
years.
keep that secret? Yeah.
Right.
Yeah,
No, that's good.
They would have patented that. That would have been able to be reproduced probably in the 100 years ago at this point.
That's right.
That's an important note, though, right? That patents are they're not intended to be blockers for innovation. They're intended to enable innovation. You can actually, if you patent something, you can license to other people who can reproduce your manufacturing for this magic, for the magic glass that's protecting your cell phone or something. Yeah, that's so. Yeah, so if it's a trade secret, though, what is your theory? How does Coke keep that recipe protected? They're going to sue people if it get the employees, or there's some lockdown around that recipe.
Right. So that is important to understand, is that a trade secret is only protected as long as it is a secret. Mm-hmm. So one of the most common scenarios that happens in Silicon Valley is that employees move around a lot. They go from company to company, and they take that knowledge with them. They take all of the knowledge of what could have been your trade secrets when they go to their new employer. And oftentimes, that is their value to the new employer, is the fact that they have work experience in that area of technology. Now, your employees, I'm sure, if you are working with Good Employment Council, are going to be asked to sign some sort of agreement, confirming that they're not going to use any trade secret information and not going to take any trade secrets with them, any materials related to software code or technical specifications, anything that's the property of the company. They're supposed to return all of that. They're not supposed to take it with them to their new employers. But oftentimes, even assuming the best of intentions, it's really hard to eliminate that knowledge in their heads. And so this is how most litigation around trade secrets manifests, is when one employee leaves a company, especially those key high-level engineers and architects, when they leave a company and go to a competitor coming out with a very similar product, that is when a lot of trade secret litigation tends to get triggered.